Dear students, if you want to get more updates with regard to shorthand, please subscribe my YouTube channel. My channel name is Naganand Edumudi. I am going to dictate a passage relating to shorthand, that is 90 words per minute. 5 seconds. Start. The first petitioner, a private company, is in the business inter alia of supplying the necessary manpower to be deployed for rendering security services to various organizations, including public sector undertakings. Since the labor enforcement officer, central, the first respondent, an authority under the Government of India, launched prosecution against it, the first petitioner sought a declaration from this court through this writ petition that the first respondent is not the appropriate government to prosecute the petitioner. It has further sought a declaration that the said prosecution launched against the petitioners in STC number 1731 of 2005 on the file of Additional Chief Metropolitan Magistrate, Hyderabad, is illegal and without jurisdiction. Lastly, the petitioner has also sought a declaration that the notification dated 12/3/2001 issued by the second respondent, that is Ministry of Labour, Government of India, is ultra vires the provisions of the Minimum Wages Act 1948, for short the Act 1948. The facts in brief, as has been pleaded by the petitioners, are that the first petitioner is a company incorporated under the Companies Act 1956, providing inter alia security services for its various clients/customers. The first petitioner is said to have obtained certificate of reservation under the provisions of Shops and Establishment Act 1988 Estate Enactment. In terms of the provisions of the Shops and Establishment Act, the first petitioner is a commercial establishment and has the application of Minimum Wages Act with regard to the services that have been notified by the state government. On 1/4/2005, the first petitioner deployed its security personnel at the premises of IDBI Bank at Lucknow, it being one of its clients in the wake of a written contract entered into between these two entities. Later on, 25/5/2005, the first respondent visited the premises of the first petitioner and noticed certain alleged irregularities in maintaining the records. As a result, the said authority asked the petitioners to ensure compliance with the same in accordance with the provisions of the Act within 15 days. The first respondent further at that time seems to have observed that the petitioner's deployment of its personnel at IDBI Bank constitutes a scheduled employment under the Act and the provisions of the Minimum Wages Act, as has been notified under on 12/3/2001 by the Ministry of Labour, Government of India, in notification number 216 Class E applies. On 10/6/2005, the petitioners submitted an explanation to the first respondent stating that it had been complying with all the necessary regulations by displaying in English and the notices and other procedural parameters. Despite the receipt of the explanation of the petitioners on 18/11/2005, the first respondent launched prosecution before the Additional Chief Metropolitan Magistrate in STC number 1731 of 2005. Since the matter was taken cognizance and the petitioner numbers 2 and 3 are sought to be tried, all the petitioners have approached this court by filing the present writ petition seeking the reliefs referred above, including the quashing of the criminal proceedings. In the above factual backdrop, Sri Sridharan, Land Counsel for the petitioners, has submitted that the notification dated 12/3/2001 has no application to the first petitioner establishment, since in terms of the definition of the expression the appropriate government, it doesn't take into its fold the first petitioner establishment. The Land Council has also contended that as per the said notification, the minimum wages as fixed by the union government could be applicable if the security personnel are engaged in the service of public sector enterprises alone. It is undisputed that the first petitioner engaged its personnel not only in the public sector enterprises but also private entities. According to the Land Council, it would be incongruous to hold that same personnel deployed by the same principal employer. Stop.